Lordship, if I may be allowed to mention from part 2,
Yes.
if item 3 can be adjourned till after the vacation.
Item?
3, part 2, item 3.
When do you want it?
After the vacation.
As prayed for by Mr. A.R. Malhotra, learned counsel appearing for the appellant, which is not opposed by the respondent, relist after 4 weeks on a date to be fixed by the registry.
Your Lordship, this item 4 it may be taken up tomorrow.
Okay.
Finally, Your Lordship, regarding item 16, the last item, the matter can be posted for final hearing after vacation, Your Lordship.
As prayed for by Mr. Jonathan L. Silo, relist, give a date after the vacation. Don't give a date. Relist in the month of February on a date to be fixed by the registry.
Obligation.
Learned amicus curiae. Yeah? Yes, Miss Mary?
Your Lordship, with respect to item number 6, 6, 9, 12,
Of
and
part 2.
14 of part 2, yes, Your Lordship.
6,
6,
9.
8, 9, 12, and 14.
Yes.
I have some personal difficulty to conduct a hearing. So if this matter can be posted after vacation, I have taken the consent in all the cases.
Okay. In all these cases, you must be for the respondent.
Yes, yes.
You say with consent, huh? And after the ensuring vacation on a date to be fixed by the registry.
I'm deeply obliged.
Pranam.
Daily list for admission, item 1.
Mr. Lalfaghwala,
Yes, my lord.
the appears that the court's order could not be communicated.
Yes, my lord. My lord, I respondent number 4 and 5 for personal appearance. They are present today.
4 and 5. Let them be there. 4 and 5 is present.
4 is Mr. Siddiqui and
Please give the names. Huh? Michael, take the names. R4 and
R5.
R5 is present.
Yes, my lord.
Now, I want the names.
Uh,
Ask them to sit in the front. Please make them. You are representing them otherwise?
yes, my lord.
Take your seat. Take your seat. You are 4 and 5.
Yes, my lord.
What about 6?
6 has already on last occasion his appearance has been dispensed of, and personal appearance he appeared. He is today present at the back.
All right. All right. Otherwise dispensed.
Yes, my lord.
And what about 7?
7 is
Seven,
Ministry
Your
of
Lordship.
Home Affairs.
Your Lordship may kindly come to the order dated 16/10, 2025 passed by this court.
16?
16/10, 2025. In the last page, second paragraph.
1610.
Yes, my lord. 16.
Yes, yes. I have 1610.
Yes, my lord. In the second last paragraph, last page,
Yes.
5 lines from the top, my lord.
Yes.
Moreover, in view of the provisions of Order 529, subclause 5 CPC, presumption of service on respondent number 7 is hereby drawn. The respondent number 7 is granted an opportunity to facilitate compliance with the judgment and order of this court dated 4/12/2019 in WPC number 71 of 2018, so that coercive measures need not be resorted to. Now, this court has already taken judicial notice that the contempt petition has been received by the respondent number 7. But in spite of that, the respondent number 7, who is the Secretary to the Government of India, Ministry of Home Affairs, Department of Border Management has failed to appear or take any
Mr.
steps.
Lalpakswala, what is this case
This
about?
is a case with regard to non-payment of compensation regarding
Where is the order?
My lord, there was an order. WPC.
Mr. Counsel, you please take your seat.
Yes, my lord.
Yes, Mr. Lalpakswala?
Yes, my lord. I'll take your lordship to page 120 of the contempt petition. my lord. 120. This is the order passed by the learned single judge in WPC number 71 of 2018.
Yes. So this is the order against which the non-compliance
Yes,
has been
ma'am.
alleged.
Yes, ma'am.
Let's
Now-
read. What is the operating part of this order?
I'll come to page 126, para 13.
Yes, please.
Upon making such calculation, the collector shall forward the same to the respondent number 3 to 6 and who shall make necessary arrangement of the fund required as expeditiously as possible and preferably within a period of 3 months from the date of receipt of the requisition of fund from the collector. All the respondents shall coordinate and ensure that the petitioners get their due compensation without delay. Now, the learned single judge has passed an order in favor of the writ petitioners.
So the order of 2019, December 2019, mandates the respondents to take necessary arrangement of the fund required as expeditiously as possible and preferably within a period of 3 months from the date of receipt of requisition for fund from the collector.
Yes.
All the respondents shall coordinate and ensure that the petitioners get their due compensation without delay.
Yes, ma'am.
Till date, you have not received your compensation.
No, no.
Correct?
Yes, ma'am.
Now, first of all, has the collector gave the funds
Yes.
that has
The
come?
collector has calculated their work and it was received by the respondents.
So that is on record?
That is on record.
Where?
Your lordship will come to page 177.
Yes.
Now, this is the assessment made by the district collector in compliance of the order 412
Yes.
2019 made by this honorable court, and the addressee here, your lordship will see. the
Details
chairman-
of payment.
Yes,
On this, you are kindly informed to deposit the amount. So this has been given to all the respondents.
yes.
Now, what has happened? Why, Mr. Goswami? Why is this order being not complied?
Yes, my lord. Thereafter,
We are in 2025.
Yes, my lord. Thereafter, we went for writ appeal.
That I am not interested.
No, my lord. I would
What
have
is
to.
the reason for not compliance till date? As on date, is there any appeal court's orders
No, my
setting
lord. My
aside?
lord, it
Is
has
there
been-
a stay order?
My lord, it has today. I have filed one affidavit, wherein, as per last order, I was told to file an affidavit by respondent number 6. Respondent number 6 has already written for approval of the amount 22 crores, which has been already revised, my lord. So that has been by the deputy commissioner has given a revise, because in the meantime writ appeal took place, then SLP took place, then review took place. Now then we send that we have sent it that estimate of 22 plus crores to Ministry of Home Affairs. Ministry of Home Affairs has sent it to the legal department. Now it is pending. It is it is waiting for report of the Attorney General.
Mr. Goswami, this
Yes.
court is only interested to
Yes,
know
my lord.
by when these amounts can hit the account of the petitioners,
Yes,
because
ma'am.
there is a order of this court way back in December 2019. Today, now we are almost in the end of 25, and the ground reality is that till date, this amount has not been deposited in the accounts of these petitioners, despite contempt being filed.
Yes, my lord, it is the paying.
So I am only, I am not, Mr. Goswami, please be mindful. I am only asking when it can be complied. I am now not, I am not trying to
My lord.
intimidate you and asking for some kind of
My lord, that
answer which would provoke this court to pass some other adverse
My lord,
order.
that-
A very simple question has been
My
posed
lord, that
before
question
you.
has to go to MHA. MHA is also a party in this petition. We have wrote to MHA for payment.
Who is MHE?
Ministry of Home Affairs.
Who is appearing for
My-
them?
My
Who
lord,
is the that respondent number
no,
is?
I am not representing.
No, who is the respondent contempt?
CGST is representing.
Sangpui.
None as of now represented the respondent
No,
number
but
7.
this is the only difficulty this court is facing in these contempt proceeding in this court, that most of the contempt proceedings, a few of the respondents are not being represented. If the respondents do not choose to represent themselves by engaging a lawyer, the court will have to issue arrest of warrant, get them appeared.
My lord,
What else can be done?
My lord, last para of the same order reads says, registry is directed to communicate a copy of this order to respondent number 7, that is
So
Rajendra
that
Kumar.
has been that has come, that not found.
My lord, Secretary of Government of India is not found.
No, I think this postal note is regarding 4. Who is 4?
4 is, my lord, he is there.
You are for 4?
Yes, my lord.
So you are already appearing.
Yes, my lord, and he has retired long back, my lord, in December.
You
itself.
see, Mr. Goswami, please don't tell me about retirement
Yes,
in
ma'am.
this court. This court is not interested about retirement.
Yes, my lord.
Because once you are arraigned in the contempt proceeding, your responsibility
Yes, remains.
does
my
not
lord.
go away. Obviously, if you are not in the holding that post, Mr. Officers, then situation would be different. But you have to give an affidavit. Have you both filed any
Yes,
affidavit
yes.
before this court?
Yes.
You have filed.
Yes.
So you have explained your position before
Yes,
the court.
yes.
And
My
you-
lord, 2 affidavits.
and
have-
in your 1 second, Mr. Goswami.
Yes.
And you have also given your unconditional apologies or whatever in the
Yes,
affidavit, right?
Yes.
All right. Please take your seats. Mr. Lalfazwala, what happened to this communication to R7? It says it came back unserved. Why it came back unserved? Have you checked the court file?
Yeah, I have checked it, but
What is the reason?
nothing has been written in the office, not my lord.
He is the secretary to the government.
He has,
His office is right there, I
he is-
think.
this honorable court, my lord,
Where is his office?
in New Delhi.
No, there is no one from here, the central government officers.
No. It's represented by the CGC only. But now they have not engaged the CGC.
Why has it come back like this? Ms. Ankvi, you are the CGC counsel? No, I know, but otherwise you are a CGC counsel. Huh? For the? Correct, but for central government, right? Are you a central government counsel for Mizoram or not? Who is the CGC? Mr. Lalfazwala, who is the...
She is the CGC.
Correct, that's why I'm asking. So, you can always communicate to this Dr. Rajendra Kumar. You send him a communication. You do give him official communications whenever you are representing in a case of central government, are you not? Ms. Ankwe, please understand you are an officer of the court. Now, the court is finding difficulty to proceed with this contempt proceeding because of not being able to get this contempt notice delivered to this Dr. Rajendra Kumar, who is supposed to be the Secretary to the Government of India, Ministry of Home Affairs. Now, you are one of the central government penal counsel. So during court cases, you are often communicating to the officers in the New Delhi office, are you not? So you send them a detailed letter indicating the order I'm going to type today, and we will see if he chooses to appear. If he doesn't, then on the next date, we'll issue an warrant of arrest, we'll get him arrested. What else can be done if he doesn't choose to appear? But right now, we don't know whether he is aware of it or not, because this has come back, which is strange because just show this to her. I think the address and everything is correct, isn't it? Just have a look, Ms. Angpui, because you are regularly communicating to them. You are a penal counsel and an officer of the court. So, Mr. Lalfagwala, if I understand correctly, as of now, we don't, nothing needs to be done from 4 and 6, 4 and 5. 6 has also filed their affidavit. I think their personal appearance can be
Yes,
dispensed.
my lord.
There is nothing from their end.
But they have to stay in the journey because we have not reached the
No,
point
no,
of this.
we are not releasing the, we are only dispensing their personal appearance in the court.
Yes.
We are not striking off them as raid parties. Now, where are their affidavits? Which page, Mr. Goswami?
My lord, today they have filed it.
Oh, they have filed today.
Yes. Earlier they have filed it once, and today there is another affidavit. They have filed that stating that he has retired respondent number 4 and respondent number 5 10
So
years
let me
over.
do one thing. Those affidavits are not on record right now.
Yes, ma'am.
So I'll have this matter posted tomorrow. However, they need not be personally present in the court. Your counsel is Mr. Goswami, right? Both
My
of
lord,
you.
I won't be there, my lord. I am having I have some medical issues. My blood pressure is.
So then we'll have it at 2 o'clock.
My lord, maybe after vacation.
Mr.
No,
Ros-
no, no, no,
Mr.
no.
Roshan is here.
Mr. Roshan is there?
Mr. Roshan is there. Mr. Roshan would be there, my lord.
Mr. Roshan is here.
Very well. Because I want to see what is there in the affidavit and I want to record
I
that
have a
affidavit in
copy
the order.
If my lord would like to, or otherwise, if it.
Yes, Ms. Angpui, have you seen the envelope? The address I think is okay. You do one thing. Then you do one thing, Ms. Angpui. Please be there at 10 o'clock tomorrow. I'm posting this matter tomorrow. You please have a look at this. And you try and give a call to this person if you can. You see, because he has to be represented by a lawyer. If he doesn't want, then we know what to be done. So inform him that this is the problem. If he instructs you to appear, well and enough. If he doesn't instruct you, you let me know. But we need to know. Okay. Heard Mr.
P. Goswami.
Mr. Lalfagwala, learned counsel appearing for the petitioner. Also heard Mr. P. Goswami, learned counsel appearing for the respondent stroke contender number 4, 5 and 6.
Yes, ma'am.
None appears for the remaining contemners on call. It appears that despite this court's order to the registry to to communicate the court's last order to respondent number 7, however, the same came back unserved on 13/11/2025. Mr. Shri Gufran Uddin Siddiqui and Shri Ranjan Kant Agarwal, Rajnikant Agarwal, respondent stroke contender numbers 4 and 5 are also personally present in the court. In view of as per the last court's order, the contender respondent numbers 4 and 5 has also filed their respective additional affidavit. Both has filed, na?
Yes, ma'am.
Additional affidavit before this court today.
Yes, ma'am.
However, the same are not on record. Let registry verify and place the same on record by the next date of listing. It appears that the stand of the respondent stroke contender numbers 4 and 5 is that they have done the necessary procedural requirement for releasing the fund in question. However, it is pending at the end of.
My lord would see another affidavit. I have given copy of respondent number 6. My lord, just now I have given. It is with my copy only.
Which copy? This one?
Yes, my lord. Respondent number 6, Dr. Y.L. Singh.
Yes. This also you filed today?
Yes, my lord.
Yes.
My lord, the last page, page number 7, would clarify, my lord.
However, the matter is pending at the end of the Ministry of Law and Justice in order to get the opinion of learned Attorney General AG on the matter.
Yes, my lord.
No, but who is appearing for the Ministry of Law and Justice?
No, my lord, not party is not.
R7.
R7 is Ministry of Home Affairs. Home Affairs has sent it to Ministry of Law and Justice. Because
You all are not cooperating with the court to come up to a solution. Mr. Siddiqui, you are Mr. Siddiqui? You are Mr. Siddiqui. Mr. Siddiqui and Mr. Agarwal, please tell me, how do we get the order of the court? Who is the person now we need to get hold of to get the order of the court compliant? The R7, correct? He is the one because he is the secretary to the government.
yes,
Full stop. এই ওপৰত যে এফিডেভিটছ বুলি দিবা তাৰ আগত ক'বা এওঁলোকৰ এফিডেভিটটো ক'লাতো that apart that apart an additional affidavit has also been filed on behalf of respondent number 6 today. However, none of the 3 affidavits are on record. Then you say this and you apt to extract and then you say it appears that the presence of respondent number 7 is important in order to proceed further in the contempt proceedings. MS Sangpui, learned Central Government Counsel, who is present in the court, is requested to inform the office of the, give me that envelope. Is requested to inform the office of the Secretary to the Government of India, Ministry of Home Affairs, Department of Border Management, New Delhi, as regards the contempt proceeding pending against Shri Dr. Rajendra Kumar, Secretary to the Government of India, Ministry of Home Affairs. Relist Thursday? I will relist it on Thursday, Ms. Angpui, or tomorrow? Relist tomorrow. MS Sangpui shall further intimate the office as regards their right to engage a counsel of their choice if they are so advised. MS Sangpui shall further obtain the correct address in order to communicate the notice of this court to Shri Dr. Rajendra Kumar in view of the fact that the earlier communication has been returned back without any postal remark. No, have been returned back being unserved, including his personal address. You get it from the office, they will know it. Your central government office in New Delhi will know the residential address of Dr. Rajendra Kumar. It's a central government office, including the residential address. So you get me both the address, his permanent address, residential address, and his official address. Am I clear, Ms. Sangpui? Yes. Release tomorrow, personal appearance of so-and-so, so-and-so, sends discharge for the time being.
My lord, if I may be allowed to make one further submission with your lordship permission, my lord. In the previous court date, my learned friend has furnished a copy of letter written by the Under Secretary to the Government of India, Ministry of Home Affairs. Now that person is also needed to be implemented in this case.
So that you have liberty.
Yes, my lord.
In the meantime, Mr. So-and-so is at liberty to, no, but you see that you do it, when you do it, we will see, because we don't know.
Yes, my lord.
Since they have
So
returned
you
also-
file an application,
file.
Mr. Lal
Yes,
Fakjwala. Unless and until you file an application, how can the court pass an order? I'm not going to give you a liberty to bring someone right now. We don't know who is this person.
If it please your lordship,
Yes, you file it.
my lord.
There is nobody is going to stop you from filing. Once your eye is placed before the court will exercise its mind. All right, Mr. Siddiqui and Mr. Agarwal, I am not recording the presence of respondent number 6 because
Not
today
required, my lord.
it was not required.
Yes, my lord.
Right.
But all right, Mr. Goswami, ensure that tomorrow someone from your side is present, huh? And you get these affidavits. Huh?
Item numbers 2 and 3.
Yes. Now, before we start the next matter, I see some young students are in the court today. Let me welcome them. They are from, I think, some teacher. One teacher is also there. Yes, please get up. Chibai. I welcome you to my court. They are class 4 students accompanied by their teachers from Government Langpui School, correct? Primary school. Yes. Please make yourself comfortable. Yes.
Lordship, in this case,
Yes.
the petitioners in WPC 17 of 2024 and in WPC 12
Mr.
of
Lal
2023,
Fakdwala, Mr. Lalram Zoba, these are land compensation
land
matters.
compensation matters. Yes.
You have not been paid till now.
We have not been paid.
What is the stand of the government?
My lord, it is a lapsed order that has been
It's a-
lapse proceeding has lapsed, and that has been admitted by
Pleadings are complete.
pleadings are complete. My lord, it may be admitted and fixed for hearing, my lord.
All right, I'll fix it for hearing then.
Yes, my lord.
Heard,
Lordship,
Mr. Huh? You want to say something?
Lordship, the fact that it is lapse is not denied, but in view of the provision.
No, but this matter needs to be heard, right, Mr. Lalram Zoba? So since the pleadings are complete, we'll post it for hearing. You
Next
can-
week, next week.
Next week.
My lord, after vacation, 22nd.
Because it has been long pending, Your Lordship.
It's a
There's nothing
25
much to do.
24
There's
matter.
nothing much to do.
We'll post it immediately after the reopening then.
Yes,
Heard Mr. C. Lalram Zwaba, Learned Senior Counsel, assisted by Mr. Stephen Lal,
Lalpur.
so and so, Learned Counsel for the petitioner. Also heard Mr. P. Goswami, Learned Counsel, appearing for respondent numbers 5 to 7. Ms. Angpui, Learned CGC for respondent number 4. And yes, are you appearing? Lalin Nui, Learned Counsel, appearing for respondent number 1, 2, and 3. Pleadings appears to be completed. The matter requires a full-fledged hearing. Admit no formal notice as parties are represented by the respective councils. Relist for hearing in the month of February.
If I may, Lordship.
First week, huh?
I represent the petitioners in item number 3, Lordship.
And for item number
That
3,
is
Zoram
stuck together,
Chana, na?
My lord.
Mr. In item 3, everything else remains same except petitioner's name is C. Zoram Sana. Okay. In the month of February, first week,
Actually, my lord, if it can be taken up next week, I say, wait, there is urgency, Lordship. Now,
Mr. Goswami seems, he says he is not going to be here or something. Are you here
Yes,
or not?
my lord, if they are having so much of urgency, they can go today itself. Why
No,
should
no,
we-
not today. Next week, are you here?
No, my lord. My lord, I can come.
Where are you from?
My lord, if it is fixed in the
You're not
first,
from here.
my lord, I'm not from here. I'm from Guwahati, my lord.
Okay.
I think, my lord, he can also appear through VC because now he have already submitted everything he has to say, man. So,
My lord, I have to submit my citations and all. I would have to show it.
All right. In view of the urgency canvassed on behalf of the learned petitioner, relist this matter next week on a date to be fixed by the registry for hearing. Since you are not giving a date, registry will give a date on which date the learned counsels appearing for the respondents are at liberty to join the hearing through video conferencing mode if they are so advised.
My lord,
Yes, next.
Item 4.
Lordship, the instant case is also more or less the same thing. It is arising out of different awards.
Yes, Mr. Lalram Zaba.
This
Additional affidavit was required to be filed on behalf of 5 and 7. Who is appearing for 5 and 7?
5 and 7, they are being represented by D. Gogoi. D. Gogoi from Guwahati.
Where is he?
Mr. D. Gogoi appears to be absent today.
But that affidavit has not come till now. On the one Mr. Silo, Lalchan Seema Silo had appeared for 5 to 7. Granted 3 weeks time.
5, 6, and 7, they have filed their affidavit,
No. Not yet filed.
which we have received on 5.
Additional affidavit.
5, 6, and 7.
When?
On 5/12, no, 5/12/2024.
No. On the last occasion on 7/11/25, they took time to file additional affidavit.
No,
That has not come.
they have not filed their.
Heard Mr. C. Lalram Zawal, Learned Senior Counsel, assisted by Mr. Stephen, no? So and so, Learned Counsel appearing for the petitioner. Also heard MS Lalden Pui.
Lalnud Louis.
Lalden?
Lalnud Louis, Your Lordship.
Lalden Nui.
Yes, Your Lordship.
Learned, just write her name. No? And MS Sangpui, Learned CGC. For respondent numbers, please give your respondents respectively. None appears for respondent number 567.
No.
567. It further appears that though on the last occasion, i.e. 7/11/25, Mr. Lalchanhima Silo had taken 3 weeks time to file additional affidavit. However, nothing has been filed till date. That apart, there is no representation on behalf of the said affidavits on call. Be it as it may, relist on such and such date, on which date also, if there is no representation or any additional affidavit filed on behalf of the aforesaid respondents, the matter shall proceed in accordance with law. Give a date. Give a date, yes. When can we have it? Next week?
It can be listed next week also.
11th of December.
At least it will proceed.
Item 5.
May I please, Your Lordship?
Yes.
My Lord, I am appearing for respondent number 6 and 7 in this case, Lordship. Lordship, we are supposed to file our affidavit, but due to some personal difficulty, my Lord, it could not be filed, my Lord. My Lord, if otherwise affidavit is ready, we have already served copy to the other side. So, my Lord, I am praying, my Lord, let it come up after some time, my Lord.
I have not heard anything.
Lordship,
Yes.
I am appearing for respondent number 6 and 7, my Lord.
Yes.
We are supposed to file our affidavit, my
Yes.
Lord. However, my Lord, due to some, my Lord, administrative reason, that could not be filed, my Lord.
Yes.
Otherwise, affidavit is ready. We already served copy to the other side. My Lord, I am praying for further 2 weeks' time to file our affidavit, my Lord.
Further?
2 weeks, Lordship.
But you said your affidavit is already ready and
Ready, it has been served to us.
has been served. Then what 2 weeks you
Yes,
need, Mr. Chetia?
My Lord, we have to send it from Guwahati, my Lord.
So
Due
you
to
need
some-
2 weeks for an affidavit to come from Guwahati?
My Lord, at least 1 week, Lordship.
You are for whom? You are a standing counsel for which department?
My Lord, Income Tax Department, 6 and 7, Lordship.
So they don't
Respondent-
have an office here?
My Lord, they have an office, my Lord.
You
However, my
ask
Lord-
them to go to Guwahati and get it and file it.
My
I'm
Lord,
fixing
my
it.
Lord, my Lord. Lordship, we'll
What
file
is
it,
this
my
2
Lord.
weeks business? Their seized materials have been, this is for release of seized
Yes,
materials.
Yes, Lordship.
The materials are being seized.
Lordship.
This
Lordship.
application, this criminal petition is for releasing of the same. Your affidavit is already on, you are filing it today. You have received the copy?
Yes, yes.
What is the stand in the affidavit, Mr. Lalram Zwaba?
The stand that they have taken is that the applicant, who is the petitioner here, she denied to be the owner of the seized material.
She denied to be the?
She denied to be the owner of the seized material. The fact is
My
that
lord.
we have not denied anything. We have claimed the right over the seized property, that is
Who are
cash.
you?
I'm running a business at Zaukothar, Champai, Zaukothar. And in connection with my business, a lot of
So
food
this
items.
is about a cash of 1 crore 3 lakhs
1 crore, yes,
97,000. Mr. Chaitya, by when
Lordship.
can we have this matter?
Lordship, let it be on 12th, Lordship.
No, 12th is too far. I'm fixing it on Monday. You make arrangement to file it by then.
Let it be on Tuesday, Lordship. Next
Monday,
Tuesday.
why Tuesday? Today is
Monday.
Monday, so you have a week's time.
Lordship.
You have a week's time. You know how to get the matter filed. Your officers
My
can
lord,
come.
right.
You can send your junior.
Lordship.
Heard Mr. C. Lalram Zwaba, Learned Senior Counsel, assisted by Mr. Stephen Lalbutsiaha, Learned Counsel, appearing for the petitioner. Also heard Mr. S. Chaitya, Learned Standing Counsel, appearing for respondent number 6 to 7, and MS Vanesyami, Learned APP for the state of Mizoram, respondent numbers 1 to 5.
1 to 5.
Stop. Mr. Chaitya's so-and-so submits that an affidavit has been filed. However, an affidavit has been served upon the petitioner. However, the same could not be filed today in court could not be filed in the court. Stop. He further submits that 2 weeks time be given for filing the affidavit, as the same is being prepared at the principal bench. The times for 2 weeks appears to be unreasonable, in as much as the affidavit is already ready and a copy of the same has already been filed to the office of the Learned Senior Counsel. The officers of the Income Tax Department is required to act more diligently and in a reasonable manner in court proceeding. Release this matter on Monday such and such date, to by which date the said affidavit should be brought on record. Yes.
Your Lordship, in the meantime, since you have received a copy of the affidavit,
In
you
the
will act to
meantime,
file a reply.
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 In the meantime, the petitioner is at liberty to file any reply if they are so advised.
Item 6.
Time of death.
Yes, respondent 1 to 6.
Yes, my lord. Respondent 1 to 6. Actually, they haven't been represented yet, my lord.
Not represented,
Yes.
but copy served or not?
No, my lord. In the last court, there was some technical difficulties, my lord.
Some what difficulty?
Technical difficulties because it was done through VC.
Oh,
And
Ms. Anku is appearing for whom?
I appearing for respondent number 7. I received instruction by stating that
Who is 7?
respondent 7 is Ashish Kumar,
Ashish Kumar.
He is the joint secretary.
former joint secretary, my lord. That is why he was already transferred out.
He is the border management. The same office is that in the other case, isn't it?
Now he already transferred out on 12/7/2024.
Now, is anybody appearing for 1 to 6?
Not yet, my lord. So, my lord, if I may be allowed to take a fresh step upon respondent 1 to 6.
All right. As prayed by MS
Ruth Lalwatfeli.
Ruth Lalruthfeli, Learned Counsel, appearing for the petitioner. The matter is reposted to the month of January 2025 on a date to be fixed by the registry to enable the petitioner take fresh steps in respect of respondent stroke contender numbers 1 to 6. In the meantime, he is retired.
Not retired, relieved from his service,
He's, huh?
relieved from his service. from the
MS,
ministry.
MS Sangpui Leonard CGC further submits that the respondent contender number 7 in the meantime has has been
As per the letter, relief. from
has been
ministry.
relieved
Yes,
from the post of Border Management, 1 Division, Ministry of Home Affairs, North Block, Central Secretariat, New Delhi, 110001, as per the letter dated
30 June 2025.
30 June 2025.
25.
Let a copy of this letter be also furnished to MS Ruth so-and-so in order to enable her to do the necessary if so advised. You might have to bring the new incumbent, huh?
Yes, my lord.
So if you know the new incumbent, please give the information to MS Ruth.
Obliged.
And you give a copy of that letter here also, huh? Ms. Angpui, a photocopy of the letter and a copy of the letter be placed on record as marked as X. You take a copy.
Item 7.
Your Lordship, as per the last order, we have received a copy of the order sheet of TCR. So if the matter may be put up for admission after the vacation.
You have not received what?
We have received a copy of the order sheet of TCR.
You have received
Yes, this morning.
today.
Yes.
Oh, and but what about this is for amendment of plaint,
Yes, my lord.
huh?
Yes, my lord. The petitioner before the London Trial Court had applied for, submitted an application for amendment of their plaint, but that was rejected, my lord.
Okay, but she said that the registry has given this today.
Yes, ma'am.
When do you want it?
After vacation, Your Lordship.
Your name?
Sarah Lal Vensangi.
MS so-and-so, learned counsel appearing for the petitioner submits that a copies of page numbers 1 to 38 of the order sheet of the TCR in terms of the last court's direction dated 21/10/2025 has been furnished to her office by the registry only today morning and accordingly seeks a short accommodation. Prayer is not opposed by Mr. C. Tianga, learned counsel appearing for respondent number 5 and by MS so-and-so, learned government counsel, na? Learned government counsel. Lanin Louis. Repost on such and such date. Yes.
Obliged, Your Lordship.
20th of January. Item 8.
Execution case, Mr. Malhotra.
Affidavit is still awaited.
Yes, Your Lordship. I've received the affidavit, and if I may be allowed at least 1 week's time,
All right. Heard Mr. A.R. Malhotra, learned counsel appearing for the petitioner. Also heard MS Lalan Louis, learned government counsel appearing for respondent numbers 1 to 6. MS Lalan Louis, learned government counsel, submits that she has received a copy of the
pairwise comments.
pairwise comments and shall be filing the affidavit
next
shortly.
week. Yes, Your
In view of the aforesaid endorsement made by the learned government counsel, relist, yes, after
After?
Your
2
Lordship.
weeks?
Yes, Your Lordship.
After 2 weeks? After 2 weeks and a date to be fixed by the registry.
Much obliged, Your Lordship.
Item 9.
Rima bond. You want a reduction? Yes, Ms. Vansiami.
Yes, Your Lordship.
I think I can call you Vane.
Yes, Your Lordship.
That would be easier because there are few names I feel I'm comfortable in pronouncing. Few names every day I jumble. I'm sorry. From planes we have this difficulty. I try as much as I can. Yes. So, Ms. Vani, you have you filed any objection or you don't have any objection otherwise?
Your Lordship, I have some objection, which I will place in verbally, orally. So, Your Lordship, my objection is that...
1 second, let me first hear them then. Yes.
Yes, my lord. This is regarding the reduction of Zima Nama bond.
Why you want reduction?
My lord, if I may take your lordship to page 27.
Pranav. To he contempt on Nami.
The relevant portion is at page 35.
Page
35,
35.
yes. This is your lordship order, and if I may read, my lord.
1 second. The order starts at which page?
27.
Yes.
Yes. If I may read, Paratharthi, my lord.
Yes.
As such, the Learned Judge Special Court NDNPS Act Aizol is directed to release the seized vehicle, motor vehicle Tata 1816 LPT brick, red color bearing registration number AS28 AC 1618, chassis number so and so, NG number
What
so
is
and so.
wrong in this order?
See, in pursuance of this order, the Learned Trial Court pass an order which is at page 36.
Yes.
And the relevant portion is at page 37.
Yes.
So in the last sentence,
Yes.
it is said that
Amounting to 15 lakhs.
lakhs.
Yes.
Yes. So the problem we face is that the trial court directed us to
That's
deposit.
the market value of
Yeah.
the said vehicle.
The problem is that whether we have to cash the deposit or we only have to execute the bond, Zimanama bond.
Execute. The applicant shall execute the JIMA bond.
So our interpretation is that we are not bound to execute cash deposit before the Learned Trial Court, that 15 lakhs. But the Learned Trial Court required us to produce an updated bank passbook in which the amount 15 lakhs amount should be available.
I don't think this, what is to be done from here? Miss Vyani?
Yes, Your Lordship, in my humble opinion, they have to submit a check
Correct.
amounting to 15 lakhs.
Correct. That's what the trial
And-
court have said.
Exactly, Your Lordship. And again, they have to produce the financial soundness, that they have that money in their bank account. It doesn't mean that they have to furnish the cash amount.
I don't think your petition is maintainable. I'm dismissing it.
But my lord, we have a problem that that's why we don't have, we could not satisfy that 15 lakhs.
Why you don't have it in your account?
Yes, we don't have in our account.
Then you give it in the check, because if you want the vehicle, that is the JIMA bond given by this court.
Then that should be clearly stated, my lord.
Clearly stated what?
That check.
No. That is the satisfaction of the trial court. This court is not going into all this. I don't think any case of any irregularity is made out. This is a criminal petition.
Yes, but my lord, at least a clarification should be there that
What clarification?
the order does not speak about to produce financial soundness, the Learned Trial Court itself.
It says the applicant shall execute.
Or we have to execute Zimanama bond only, the bond, written bond only, in my interpretation.
So that has been done.
Yes, so
Are you aggrieved by that?
we have already submit all that bond, but what the
Is it
problem we
okay,
have?
Ms. Vani, if I record this submission that it appears that the trial court has only directed to execute the Zimanama bond in writing?
My lord, in my submission, it has to be, they have to show that they have that financial soundness.
They
Just
said
by
they-
executing the check, it doesn't mean that there is a surety. In order to prove the surety, they have to show the financial soundness. It doesn't mean that they have to encash that amount.
So suppose they don't have this 15 lakhs in their bank account, then what has to be given?
So, my lord, in my humble opinion, they have to pray for reduction of bail, zima nama amount.
Before
now they were
before
not-
the trial court.
Exactly, your lordship. Now they did not pray for that. They were praying to,
Directly they have come here.
yes, your lordship.
But my lord, in the order it says only to execute Zimanama bond. That financial soundness is
See, there could be
Not
one
in the
difficulty,
order.
Ms. Vani, because this court said on furnishing the Zimanama bond equivalent to the market value of the seized vehicle
Yes, your lordship.
with further condition. I think because of that, perhaps.
Yes.
So then
and-
this court's order will also need a little bit of, I
Exactly.
think. Michael, can you get me 2002 volume 10 SSC 283? 2002 volume 10 SSC 283. Can you just send him immediately or call them up in the library? Ms. Vani, what I can do is I can clarify this court's order by saying, by taking that in case they file an application for reducing the Zimama ban, the same should be considered by the trial court, and the trial court shall be at liberty to take appropriate bond and guarantee without being influenced by the condition imposed by this court earlier.
Fair enough.
That
your
should
lordship.
be sufficient, I think.
Yes, fair
Isn't
enough,
it?
your lordship.
Okay?
my lord, the problem we have
No.
faced is that
What more problem? I am not going to do it here now.
yes, but my lord, the problem we have faced at the trial court is that which is not in the order which is required us to.
That is why I said,
Yes.
I'm going to make it clear. Your name?
J is from the Moya.
Heard Mr. J.H. Ramnel
Moya.
Moya. Learned counsel appearing for the petitioner. Also heard M.S. Vani, learned APP for the state of Mizoram. By filing this petition under Section 528 of BNSS 2023, the petitioner is seeking reduction of the Zimanama bond to be executed by the petitioner by order dated 1/8/2025, passed by the Learned Judge Special Court, NDPS Act 1985, Aizawl, Mizoram. The case of the prosecution. No, don't say case of the prosecution. Huh? It appears that since the vehicle in question alleged to be the claim to be of the petitioner was seized by the anti-narcotic squad in connection with excise case number EXN 263 of 2023 dated 28/9/2023, registered under section 21C of NDPS Act 1985. The petitioner approached this court by criminal petition 24 of 2025 for release of the said vehicle of his vehicle I Tata 1816 LPT brick red color bearing registration number AS28 AC 1618 chassis number MAT 84301 4 P7E10439 engine number so and so etu tumi paba page 28 ot trucker detail to agot di diba ha tar pisot said vehicle kori diba. This court by order dated 24/7/2025 was pleased to direct release of the said vehicle vehicle with vehicle documents and its ignition key to the petitioner on his proper identification and on verification of all the relevant documents relating to the said vehicle in original and after taking photograph of the said vehicle and on furnishing the Zimanama bond equivalent to the market value of the seized vehicle with further condition that the petitioner shall not alienate the said vehicle and shall produce it before the trial court whenever it is required in the case during the course of trial. Thereafter, the petitioner by criminal what is this SR number 111/2024? That is the case
Yes, the case registration number.
of your application for release.
My lord, that is the
Your Lordship, this is session case registration number.
Therefore, thereafter, the petitioner in SR number 111 of 2024 sought release of the said vehicle before the Special Court NDPS Act Aizol and the learned trial court by order dated 1/8/2025. Upon proper identification and verification of all the relevant documents, directed the applicant to execute Zimanama bond amounting to rupees 15 lakhs, which is estimated as the market value of the said vehicle. Mr. Zoram Sana, Mr. Ramnil Moa,
yes.
learned counsel appearing for the petitioner, submits that the petitioner is unable to satisfy the Zimanama bond as he had purchased the said motor vehicle on loan and is still under financial obligation to repay the remaining loan amount and is currently going through severe financial hardship and does not have any source of income at this point. He further submits that the said seized motor vehicle is the primary means of his livelihood and is essential for daily substance and income generation of the petitioner. He further submits that without access to the said vehicle, the petitioner is unable to earn and is further restricted in his ability to repay the outstanding loan amount. Ms. Vani, learned APP, submits that the seized vehicle cannot be return unless and until appropriate Zima bond is executed by the petitioner. Correct?
Yes, sir.
Stop. Having heard the learned counsels appearing for the parties and having perused the materials available on record, including the grounds urged for inability of the petitioner to pay the Jimanama bond, this court and upon observing that no prayer for reducing the Jimanama bond was made by the petitioner before the trial court, comma, this court in the interest of justice deems appropriate to dispose of this criminal petition by giving liberty to the petitioner to file appropriate application before the trial court seeking reduction of the Jimanama bond, and upon such application being filed, the trial court shall do the needful in terms of the earlier order passed by this court on 24/7/2025 in so and so by taking appropriate bond and guarantee for the return of the said vehicle if required by the court at any point of time without insisting furnishing the Jimanama bond equivalent to the market value of the seized vehicle. ठीक है? I think that is sufficient.
Sufficient.
Yes?
Yes.
All right. Disposed of.
Thank you
Within
very
a period of?
much. 1 week.
Yes, Ms. Vani?
2 weeks, Your Lordship.
Within a period of 2 weeks from receipt of such application in accordance with law. Yes.
For orders, item 10.
No. I mean,
That's
you
it.
just keep it. I saw it was quoted there, so I took it from them, and you keep the book. I'll see it when I edit it. Huh? Yes.
Lordship, there's an application for bail.
Hmm.
Order was passed on 17/11
This is
For-
item number? Mm-hmm.
for sending of scanned copy
10.
of the kid's record.
Your Lordship, from the information that I have received by checking the files here, the scan copy is not yet received.
Not received. So when? Next week?
Lordship, the liberty of the applicant is involved.
Yes,
Lordship,
but it's 21C. Yes, Miss Mary, when?
Yes, this is a very, very highly publicized case, Your Lordship.
By
So
when can you have it? Oh, this has to
it's the
come from-
registry.
By-
Yeah,
by-
it has to come to the registry.
From Champai.
Champai.
Champai is 3 hours, 4 hours maximum.
Yes, it's not good.
And
It may be
scanned
taken up
copy.
again on Friday, Your Lordship. Friday,
Friday would be difficult, Mr.
Thursday.
Lalram
Thursday.
Thursday.
Thursday. It is then heard Mr. C. Lalram Zwava, Learned Senior Counsel, assisted by Mr. Stephen Saiha, Learned Counsel appearing for the petitioner. Also heard MS Mary, Learned APP for the state of Mizoram. It is brought to the notice of the court that the scanned copy of the case records, as called earlier, has not yet been received. Let reminder be forthwith sent, relist on such and such date.
No, yes.
9th of December.
Nine.
Item 11.
Your Lordship, this is a case wherein we were confused as to whether condonation of
Or
delay and leave. Sorry. My sincere apologies, Your Lordship. Different matter.
Ms. Vani,
Yes, Your Lordship. This is an appeal against acquittal order, Your Lordship. And paper book has received by us.
huh?
Yes,
We
we
have
have received
received
the
the paper
paper book,
book.
my lord. I'm for respondent number 2.
The IA, the 255 is already done.
Yes, Your Lordship.
What about AD cards?
Complete, Your Lordship. ID card is
Huh?
complete. Everything is complete, Your Lordship. Notice is
Received by
complete.
both. So you are for the respondent
For respondent number 2.
and one?
I believe the respondent number, counsel for respondent number 1 is absent today.
But otherwise someone is representing.
Mr. Priscilla Thangmoy.
Paper book has been done.
Yes, Your Lordship.
So we can fix it for hearing.
Yes, Your
Only
Lordship.
thing, is anybody appearing for one or not? Who is
I think
appearing for?
Mr. Priscilla Thangmoy is for respondent number
Mr.?
1. Priscilla Thangmoy is for
All
respondent
right.
number 1.
Heard MS Vani, Leonard, government, Leonard APP for the state respondent, for the state appellant. Appellant, right?
Yes, Your Lordship.
Also heard MS.
Ruth Lalruat. My lord,
Ruth Lalruat
Lalruat
Feli.
My lord, if I may, if the name of my senior may be reflected.
But you're there on record
Yes, my lord.
for respondent number.
Respondent number 2, complainant.
For respondent number 2. None appears for respondent number 1 on call. It appears that the paper book has been is ready and has been furnished to the learned counsels appearing for the parties. Matter appears to be ready for hearing, repost for hearing in the month of January 2025 on a date to be fixed by the registry.
Obliged.
February, yes.
Item
Because you
12.
have very limited working days in January.
Item 12.
By please your worship, in this matter, we had taken steps for service of notice upon the respondent number 1 on 13th of May. As per the office note, your worship, the AD card has not returned, I think. So if
R1.
yes, if the registry can give a report regarding service of notice on the respondent number 1, steps was taken on 13th of May, as per the office noting.
So no, sir. Report is there.
Report is not there, I think. Only that steps were taken.
Await service in respect of respondent number 1. Relist after 2 weeks along with up-to-date service report in respect of respondent number 1.
A moment.
Item 14.
Yes.
Lordship, in this matter, we have
406 days,
for-
Mr. Johnny.
Lordship, yes, that is the
That's
delay.
quite lot.
Lordship, the-
Service of notice was awaited. Anybody appearing?
My Lordship, it's not completed. The office note
Await
27.
service.
Yes, yes.
Relist after a week on a date to be fixed by the registry.
That's my Lordship.
Item 15.
Ms. Fanai, 21C.
Yes, my lord.
Ms. Vani, are you appearing? Oh, that details could you find those details of the other case? Ms. Vani, could you find?
Yes, Your Lordship. In this regard, I was instructed to produce the status of the present case. And just now I received a scanned copy and now they are printing out, Your Lordship. So if this matter may be taken for the last item, Your
Okay.
Lordship.
Ms. Vani, you wait for some time. You
Item
have a
s-
look at it also.
Yes, Your Lordship.
Item 16.
May it please your lordship.
Yes, Mr. Biswas.
My lord, on the last occasion when this matter was called for, your lordship instructed me to produce the latest judgment on that ground of arrest, because in this case the grounds of arrest has not been communicated, which is evident from page number 15 of the bail petition.
Yes.
So, my lord, the latest judgment in this regard was rendered in November 6, 2025.
Darshan.
No, this is Mihir Rakesh Shah. It is the latest one.
Where is it?
A copy, my lord. My friend Emmanuel is there in the court, my lord. He'll give a hard
Nobody
copy.
is here. I don't see anyone. Mr. Vishwas, you are there, but here in the physical court there is none on behalf of the petitioner. I think there is lack of coordination between you and your local council, Mr. Biswas. Anyway, we have another matter. In the meantime, you give him a call. Yes, call
Absolutely.
item 17. Call Mr. Joseph's matter. He's been here since morning.
Item 17.
Yes, 30 days delay, Mr. Joseph.
Yes, my lord, 30 days.
Yes, any serious objection? Serious objections?
Yes, my lord.
Serious objections? No.
Not serious.
Huh?
Not serious.
No serious. But objection.
Yes, my lord.
Ah. Yes, what is the ground of delay?
Now, my lord, the grounds of delay is primarily because the period taken for applying for the certified copy, my lord, in the court. My lord, this reason is stated at paragraph number
3, 4.
from 3 onwards. My lord, I'll read from 5. It will become clear to your
Yes.
lordship, my lord. That the parties have been engaged in continuous litigation since 2017 concerning the service benefits of late Sri Thang Hinglova, particularly family pensions, etc. The dispute has traveled through multiple stages before the civil court and this honorable court, including RFA number 16 of 2018 and more recently RFA number 27 of 2021. That by judgment dated 27/3/2025 passed in RFA number 27 of 2021, this honorable court remanded the matter back to the learned senior civil judge Lunglei with directions to cure the defect in the written statement cum counterclaim and to thereafter proceed afresh. That in compliance with the said remand, the petitioner duly appeared before the court of the senior civil judge Lunglei on 1/8/2025 to formally sign the written statement cum counterclaim. It was on that said date that the petitioner for the first time came to know of probate case number 5 of 2025 and of the impugned order dated 15/5/2025 condoning delay in CMA number 82 of 2025 after the same was informed to them by the presiding judge. That prior thereto, the petitioner had never been impleaded nor served with any notice, personal substituted or otherwise, regarding the probate proceedings, even though the will which the respondent has sought to probate in the probate case number 5 of 2025 is also in relation to the service benefit, particularly of the family pension of the late Sri Thang Hinglova, which is already the subject matter of the long-standing litigation between the parties in the civil court and in RFAS before this honorable court. The respondent's attempt to pursue probate proceedings behind the back of the petitioner concerning the same benefits has resulted in grave prejudice. That immediately after acquiring such knowledge, the petitioner acted with due diligence and through her counsel at Lunglei applied for certified copies of the impugned order and related records on 4/8/2025. My lord, 1/8 we came to know, between there's a weekend, and so 4/8 is Monday, my lord. The certified copy was prepared and supplied only on 28/8/2025. That the certified copy was thereafter sent by the Lunglei Council via sumo service on 28/9/2025 and was received by the petitioner's counsel at Aizawl on 5/9/2025. My lord, it should be 5/10/2025. I'm sorry, my lord. It should be 5/9, but it's sent on 28/8, my lord, not 28/9. That date is wrong. my lord.
Which one?
My lord, paragraph number 10. The sumo service
On?
was on 28/8/2025. It should be, my lord.
All right.
And it was received on 5/9/2025.
5/9/2020.
Yes. That immediately thereafter, the connected revision petition was drafted and finalized and filed on 12/9/2025. The
So,
short.
this is this delay now in this CRP.
Yes.
That's a civil revision petition.
Yes, 115, my lord.
115, and in this 115 is against which order?
My lord, it's against an application allowing a condonation of delay
In that probate.
in that probate.
In that probate.
Yes.
Okay.
Lord, I'm appearing for on behalf of my senior, Mr. Shizo Kuma. My lord, we have filed for this morning.
It's all right. I'm going to condone it. It's 30 days delay.
Yes.
Condone it. Okay.
Okay, my lord.
Any objection?
No objection.
Okay. Heard Mr. Joseph Lalchanima, learned counsel appearing for the petitioner, applicant. Stop. Also heard Mr. Mr. JVL Malswam Dongliana.
Yes, my lord.
Dongliani is the district judge's surname, right? Dongliana. Learned counsel appearing for the respondent. Stop. By way of this application under Section 5 of the Limitation Act 1963, the applicant is seeking condonation of delay of 30 days in filing the connected revision petition under Article 227 of the Constitution of India, read with Section 115 of the CPC, against the order dated 15/5/2025 passed by the Court of the Learned Civil Judge, Senior Division 1, Lunglai, Judicial District, Lunglai, Mizoram, in CMA number 25 of 2025, arising out of probate case number 5 of 2025, by condoning 1281 days delay in filing probate case number 5 of 2025. Stop. Councils, you may take your seat, please. It appears that the petitioner, that the applicant is aggrieved by the order of the learned trial court, whereby a delay of 1281 days have been condoned in filing the probate. However, since while filing the accompanying civil revision challenging the said order of condonation passed by the trial court, there has been a delay of 30 days. Mr. Joseph so-and-so submits that the delay is bona fide, not deliberate, and has been caused solely due to circumstances beyond the control of the applicant. He further submits that since the applicant was not aware of the pendency of the probate proceeding, in which the delay has been condoned by the learned trial court, the delay of the 30 days in filing the present revision petition has been occurred. Stop. Per contra, Mr. So-and-so fairly submits that he has received no instruction to oppose the object the delay of 30 days occurred in filing the connected revision. Stop. Having heard the learned counsels of appearing for the parties and having perused the materials available on record, it appears that the delay of 30 days has primarily occurred due to the applicant having not been aware of the pendency of the probate case number 5. Is it probate case number 5? Probate case number 5 of 2025, and the passing of the order dated 15/5/2025, whereby the delay of 1218 days was condoned by the trial court. it appears that the applicant had come to know of the efforts of the said impugned order only on 1/8/2025, when the applicant appeared before the court of the senior civil judge Lung Lai to formally sign the written statement cum counterclaim. After this court in RFA number 27 of 2021 by judgment dated 27/3/2025 had remanded the matter back to the learned senior civil judge Lung Lai with directions to cure the defect in written statement cum counterclaim and to thereafter proceed afresh. It appears that the explanation stated in paragraphs 3, 4, 5, 3 to 13 are sufficient and bona fide. Accordingly, the delay stands condoned. I allowed CRP issue formal notice. You are appearing in the CRP also, right? In the civil revision, only one responded.
Yes.
So issue notice, no form, so and so accepts notice kore diba. And relist after 2 weeks. Okay.
My lord, the
case to
council
leave
has come.
application to Terry kore diba, notice di diba. Miss Mary was there. She left. Miss Vani, you please inform Mr. Pauto that leave application also I am issuing a notice and posting it, because otherwise I think by inadvertently I simply said post it. In that condonation, 255 days. So we'll issue notice also in the leave and that. So you file your objection in the leave if you want. That will expedite that application.
Item 16.
My lord, yes, my local council is now.
Yes,
present.
I can see him.
Yes. Now, my lord, on the last occasion, your lordship wanted me to furnish the copy of the latest judgment on this ground
You
of
are
arrest.
Emmanuel, na?
Yes, my lord.
Emmanuel. Yes, so yes, Mr. Emmanuel,
Yes.
do you have a copy of that Mihir Hajorika?
Yes, my lord.
Mihir Hajorika?
Mihir Rakesh Shah,
Ah,
November judgment, as latest as 30 days back. This is now holding the field, my lord. My lord, may come to para 45 and 46. Here in this judgment, my lord, the Supreme Court has gone one step ahead. It says not only it is mandatory, but it has to be communicated in the language the other person understands.
no, this is nothing new. This was there in the earlier case also.
But as
Communication
a
in a
direct,
language, obviously, you see, it has to be in a language that the accused understands. That is nothing new, Mr. Biswas.
because
Yes.
most of the ground of arrest. Anyways, my lord, para 45, I am relying on para 45 and 46.
Yes, now what happens if it is
Now-
not issued,
Uh,
not given?
Now, my lord, I am relying on another judgment of our High Court, my lord. In fact, that takes into account all the
No,
judgments.
That page 49, para 49 is clear. It is by now settled that if the grounds of arrest are not furnished to the arrestee in writing, this non-compliance will result in breach of the
Illegal.
constitutional and
Yes.
statutory safeguards, hence rendering the arrest and remand illegal, and the person will be entitled to be set off at liberty. So, yes.
So, my lord, that is what, this is the judgment I am
Okay.
relying on.
Yes, Ms. Vani, anything?
Yes, Your Lordship.
And page 15, your lordship will see. 1/5 of my bail petition.
Yes, Your Lordship. In this present case, the grounds of arrest has been communicated.
Communicated, where?
Yes, Your Lordship.
Page?
It is in page 15 of their petition.
Page 15.
Yes, Your Lordship.
Yes. What is there? What is the ground? Please tell me.
Here it is written that he was arrested under Section 21B
Yes.
2000 NDPS Act. Your
And
Lordship.
that's all.
That's all, Your Lordship.
Who is she?
He, Your Lordship.
Who is he?
He
He's a
is-
lawyer.
No, Your Lordship, he's Lanjapao Donjel.
No, he knows what is 21B.
Yes, he is caught red-handed.
No, he knows what
He knows.
21B is.
He knows, Your Lordship. He
No,
was
that,
caught
no,
red-handed.
no. Does he know? Where are the brief facts constituting the offense? What is required to be informed?
I understand that, Your Lordship. The brief facts is not
Anyway,
written.
it's not there. Yes. Decca, please take down. Heard Mr. M. Biswas, learned counsel, appearing for the applicant. M. Biswas, comma, Mr. Emmanuel Lalthazwala. Also, give both the names, huh? This application is filed under section 483 of the BNSS 2023, seeking grant of regular bail to the accused petitioner Langzapao Dongel, who has been in jail since 4/11/2025 in connection with Saitwal. Mr. Biswas, please, can you mute your at your end? Can you please press the mute? In connection with Saitwal PS case number 87/2025, registered under section 21B of the NDPS Act 1985. The brief facts of the case is that on 4/11/2025, upon a complaint being received from a reliable information, from a trustworthy source, stating inter alia that one vehicle, THAR B/R number MN01AW9675, proceeding from Manipur towards Aizawl, was strongly suspected to carry illegal contraband items, comma. The officer in charge, Saitwal Police Station, issued a letter of authorization empowering the complainant to conduct search and seizure under section 41(2) of the NDPS Act Accordingly, at about 5 a.m., the said vehicle was intercepted, and upon thorough search, 218.13 grams of suspected heroin was recovered, which was concealed inside a black-colored Vextron speaker. Accordingly, a FIR was registered as Saitwal PS case number 87/2025, registered under section 21B of the NDPS Act 1985. Thereafter, the petitioner was arrested on 4/11/2025. Mr. So-and-so learned counsel appearing for the petitioner submits that the arresting authority, while arresting the petitioner, has not informed the grounds of arrest to him, and as such the fundamental and constitutional right guaranteed to him under section 22(1) of the Constitution of India, as well as section 47 of the BNSS, is totally infringed by the arresting authority. He accordingly submits that the petitioner is entitled to be released forthwith. Per contra, M.S. Vani, learned APP for the State of Mizoram, submits that the grounds of arrest is evident from the ground of arrest dated 4/11/2025, enclosed as Annexure 5. Annexure 5 or 6?
This is annexure, ground of arrest, Your Lordship, annexure 5.
To the bail application, that the same has been communicated to the petitioner. I have considered the submissions advanced by the learned counsels appearing for both the parties, and also perused the materials available on record. The only ground urged in this bail application is as regard non-compliance of the constitutional and fundamental right of the petitioner, guaranteed under Article 21 and 22(1) of the Constitution of India. Apt to refer to Article 21 and 22(1) of the Constitution of India, which reads as hereunder, quote unquote. Perusal of the aforesaid provision, it is apparent that an arrestee has a constitutional and fundamental right under the Constitution of India to be informed about the grounds of his arrest at the time of his arrest. In the present case, apt to refer to the ground of arrest issued to the this ground of arrest is the under section the 47 notice.
47.
Apt to refer
47.
to the notice issued to the petitioner under section 47 of the BNSS, which reads as hereunder, quote unquote, page 15. Perusal of the aforesaid notice indicates no facts whatsoever constituting the grounds of arrest is reflected in the said notice, except that he has been arrested in connection with the case reference given, with the case under reference for alleged commission of 21B NDPS Act. Stop. It further appears from the materials placed before this court that there are no materials available in the case record to indicate that grounds of arrest have been informed to the petitioner at the time of his arrest. There is no doubt that the requirement of informing a person arrested of grounds of his arrest is a mandatory requirement of Article 22(1) of the Constitution of India. Non-compliance of Article 22(1) will be a violation of the constitutional and fundamental rights guaranteed by the said article. That apart, it will amount to a violation of Article 21 of the Constitution of India, where a violation of Article 21 and 22 of the Constitution of India is established. The statutory restrictions do not affect the power of the court to grant bail. Be it as it may, the aforesaid case being arising of an alleged offence under Section 21, B, na?
B, intermediate, B.
21B,
B.
the rigors of Section 37 is not attracted. Upon grounds of arrest being not informed, being established, it is the duty of the court to forthwith order the release of the accused petitioner. Reference in this regard is made to the decision of the Apex Court in the case of Vihan Kumar versus State of Haryana and others, reported in 2025 SSE Online SC 269, quote unquote, paragraph 21. Recently, the Apex Court in the case of Mehir Rajesh Shah versus State of Maharashtra and others, reported in 2025 SSE Online SC 2356. Reiterated that in case of non-compliance of the fundamental constitutional guarantee under Article 22 of the Constitution of India, the arrest and subsequent remand would be rendered illegal and the person will be at liberty to be set free. In the present case, there is nothing in the case diary, case record, material available on record to indicate that the grounds of arrest have been communicated to the petitioner in such a manner that the petitioner has sufficient knowledge of the basic facts of the case Hence, it is absolutely clear that the grounds of arrest was not informed to the petitioner at the time of his arrest. Hence, his arrest is totally illegal. In view of the aforesaid, this court is of the considered opinion that the accused petitioner is liable to be released forthwith. Accordingly, the accused petitioner named above shall be released on bail in connection with the aforesaid case on furnishing of a bail bond of rupees, Ms. Vani, 50,000?
Yes, Your Lordship.
50,000 each, 50,000? Yes, I see you're making a face, Mr. Biswas. With two sureties, like amount each, provided that one surety has to be a government servant to the satisfaction of the learned special judge come. Who is the special
My
judge
lord, this
here?
is Chief
Emmanuel?
Judicial Magistrate Aizol Court. Chief Judicial Magistrate Aizol Court.
Your Lordship, now the case is not charge sheeted yet, and now the accused is produced before the CJM, Chief Judicial Magistrate.
Satisfaction of the learned Chief Judicial Magistrate? Aizol? Aizol.
Aizol Court, Mizoram.
Aizol Court, Mizoram, under the following conditions. Give first, accused petitioner shall appear before the investigating officer. It's not yet charge sheeted, na?
Not yet charge sheeted.
So before the investigating officer
Investigating officer.
on each and every.
As and when called for, my lord.
As and when called?
Yes, sir.
As
Called.
and when called, he shall directly, indirectly, inducement, then I submit at Aadhaar card, PAN card,
My lord,
as applicable.
as applicable.
Yes.
My lord, I only have one submission, my lord. Since he is from Manipur, my lord, he may not know any government servant of Mizoram. That would be a very harsh condition, my lord. Let it be two sureties, my lord, because he is admittedly from Manipur. So he may not know any government servant here in Mizoram, my lord. That will further delay his detention, my lord. Release, I'm sorry.
Yes, Ms.
Your
Vani?
Lordship, in that regard, my submission is that let him try at first. Might be he knows some government servant.
In the other case, the other day we converted that government servant into what?
Government servant only. The bail order was not below the rank of LDC. and
That
it
we
was brought
converted.
to, yes,
All right,
the
let it be government servant right now. Let him try.
My lord, then can it be government servant, my lord, government servant of any state in that even, my lord. In Mizoram, I'm sure, my lord, he doesn't
I
know
have not said
anybody.
any.
He has contacted.
I have not said that one surety has to be a government servant of Aizol only. I have not said that. Mr. Biswas, you want the order or not?
Jurisdiction.
Or I am adjourning it?
Yes, my lord. No, my lord.
কি লিখিলা হেতু দিব নালাগে shall not leave the jurisdiction of the trial court without prior permission. You will not leave the jurisdiction of the trial court without prior permission. Trial court or the investigating officer?
Investigating officer.
Investigating officer. Any other condition, Ms. Vani? Because he's from Manipur.
That is good enough, I guess, Your Lordship.
Disposed of. All right, Mr. Biswas.
I'm deeply obliged, madam. I'm deeply obliged.
Should I add one more line that in the event he's unable to organize a government servant, the CJM may appropriately.
No, my lord. Let him try first.
That would be.
All right, next.
That would.
Item 15.
One second. This you give it to Decca. Item. এইকেইটা দি দিবা দেই মোক তিনটা কেস আছে I might need that. Just give me this. 1 second. I'll give it to him later. Yes.
My lord, in this bail application, our main grounds is that there are so many inconsistencies in the way the prosecution had conducted the case.
Inconsistencies in what, Ms. Ms. Fanai?
Inconsistency regarding the non-compliance of Section 42, Section 41, and Article 22(1) of the Constitution. And And there are violation, both the accused are women, and they were arrested by a
22-1, what are you showing from 22-1 violation?
22(1) violation is that, my lord, the in the charge sheet, they've just said that it was given to his father-in-law. However, there is no proof on record that it was given directly.
And in the 47 notice, ground is mentioned.
No, the grounds is not mentioned. Nothing is mentioned, my lord.
Where
If I
is
may
it?
take your lordship
Where is it?
to my lord, at page 65 is the arrest memo.
Page
65 of the application.
65.
Yeah.
Yes.
That is the co-accused, and the instant applicant is at page 68 and 69.
So he is one petitioner.
Yes, just one
So
petition.
show me his 60,
69.
69. 69 is,
Yeah, it was just this.
huh?
My lord, my lord has got it.
69 is paragraph 8, paragraph 9.
Yes, my lord. The next, the second
68.
69, my lord.
No, it
The
starts from where?
paragraph 8 and below that
Correct.
necessary.
What is the name of the accused? Lalding Pui.
Yes, my lord.
So it starts from 68.
It starts from 68, yes.
This is the arrest surrender form.
Yes,
This
my
is
lord.
not the 47 notice.
Yes, it is not. That is the only notice that is given. Intimation given
Miss
to.
Vani, because you see, when non-compliance is alleged, then you will have to show from record that it has been complied.
Yes,
So
Your
do you
Lordship.
have
If I
anything
may
to
take
show?
you to page 56.
Page
56. The present petitioner was arrested on warrant of arrest, Your Lordship. Warrant
Yes.
of arrest was issued.
Yes.
And the apex court has stated that when a person is arrested on a warrant of arrest, if the warrant of arrest is read out, it has to believe that the grounds of arrest has been complied with. So, Your Lordship, the warrant of arrest is there, and she was arrested based on this warrant of arrest. And there is no need to provide separate grounds of arrest.
Where is that?
The citation.
Yes, which paragraph?
It's in paragraph number 27. No, my lord, I'm sorry. Paragraph number 36.
1 second.
Paragraph 36.
Paragraph number?
36. If I may read out, Your Lordship.
Yes.
If a person is arrested on a warrant, the grounds for reason for the arrest is the warrant itself. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed of the grounds of his arrest. If he is arrested without a warrant, that's it, Your Lordship. So it is written clearly that if it is arrest by way of a warrant, based on that warrant, so the warrant itself is the grounds of arrest.
But where is his warrant?
It's in page 56.
Kindly refer to the subject mentioned above. It is learned that the alleged accused was female and it is needed to arrest. But this is not the warrant. What is this?
Page 55, my lord. My lord, in the warrant of arrest also there are so many inconsistencies.
No, but what is there in the warrant says is you are allowed to arrest so and so during the night for maintenance of peace to help with the investigation.
Yes, Your Lordship.
That's it.
That's it.
My lord, this warrant itself is...
In this warrant, it's only stated that, Your Lordship.
So how can that be substantial compliance of 22? Even reading out the warrant, I understand, is sufficient. But reading out the arrest, what will they understand?
In their application for warrant of arrest, it is written the section. But in the warrant itself,
See,
it is not
Ms.
written.
Vani, your own, you see in the earlier case also, you read out that communication. If you read the entire para 36, which you just relied, you will understand that
I understand.
quoting the section is not enough. What acts, what have he or she done in order to prima facie? That has to be there, you see. That you have been found with so and so. Therefore, a case of so and so has. You see, that those facts has to be there.
I understand.
Merely saying that you have committed a case under section 21B, 21C is not sufficient. The facts constituting.
I understand.
Ma'am, I am not being able to follow this warrant and this 36 correlate. We'll have this tomorrow. You have you find out. I need them better because by saying that in a case of warrant of arrest, this will not apply. I don't think that's correct.
My lord, if I may just make one submission regarding the warrant of arrest. The warrant of arrest is not in compliance of section 70 and also the schedule because the seal,
All right, at
nothing
2.
was there.
At 2.
Yes, ma'am.
हमें वो 2-3 जो जजमेंट आया था सुप्रीम कोर्ट का मैं देख रहा था वो तो मुझे Yes, I think the grounds of arrest have not been communicated.
Yes, Your Lordship.
So I'll allow the bail. That is the basic constitutional fundamental requirement. And the latest decision that Mihir Shah,
Yes, my lord.
that is the latest.
Yes, that's the latest.
Heard MS Panail, Learned Counsel, appearing for the accused applicant. Stop. Also heard MS Vani, Learned APP, for the state of Mizoram. Why are you both writing? Actually, this you follow it here, but today I got him because he was there in the earlier bail application that I was dictating. So I told him to take this also. Yes, Rekha. But my first part to DD so. Where does the application starts from? Too much of things are here. Okay, got it. By way of this application, under section 483 BNSS, read with section 37 NDPS Act, the applicant is seeking regular bail to release the accused petitioner, Srimati Lalding Pui, who has been arrested on
22/12/2023
in connection with SC number N38/2024, registered under section 21C/29 of the NDPS Act 1985.
My lord, that the grounds of arrest is at page 5.
1 second. The brief story, paragraph 4 of Baba, page 3. ইয়াতে মাৰ্ক কৰি দিছোঁ, জাষ্ট তালৈকে লিখিলে হ'ব। Yes, Ms. Fana, you were saying something?
Yes, my lord, the violation of Article 22(1) is at page 5, para 5.
Yes, I've seen. Ms. Fanayৰ নামটো দিবা আৰু per contract তেখেতৰ নামটো দিওঁতে ক'বা that fairly submits that the materials available on record does not indicate that the grounds of arrest, that the facts constituting the grounds of arrest has been communicated to the accused petitioner. Okay? Tarpisot rest, everything remains the same, except to me, yes, before whom and here to it is already the trial have started, right? Or investigation.
Yes.
Fine.
Trial.
Yes, certain.
So it to tomorrow satisfaction of
Judicial Court and DPS Act, Lunglei.
Lunglai.
Lunglei.
Lunglai. And shall appear before the trial court on each and every date to be fixed by the court, huh? Not the investigation. The rest, everything same, 50,000.
Your
Yes, my
Lordship,
lord.
in the condition, what I would like to add is that if she fails to appear before the court, warrant of arrest may
Automatically
be-
cancelled.
Yes, automatically cancelled.
Failing which, huh? Should we make it 1 lakh here? Because this
Yes,
is
1 lakh.
21C.
Yes, Your Lordship.
Bail bond 1 lakh কৰিবা আৰু সেই এটা submissionত ক'বাত মই however in this case 21B বুলি কৈ 37 not attracted সেই লাইনটো ইয়াত নিদিবা।
Your Lordship, in that regard, another submission. In the interim bail amount is 3 lakhs. So even here, if it is make 3 lakhs.
Okay. She is already on interim.
Yes, Your Lordship.
Okay, 3. Then interim bail in this case only.
In this case only.
There was an interim bail given.
Interim bail and bail extension was rejected.
No, not in this case. Interim bail was in this case.
Yes, Your Lordship. In
But
this
it
case.
was rejected
It
already.
was
my lord.
rejected.
Then don't say all that, it'll confuse. You just make 3 lakhs. Bail bond is 3 lakhs, okay? That's all?
Yes, my lord. Deeply obliged.
We have to hit perusal or scan copy of case records for the caterer.
Hearing list, item number 1.